Welcome, everybody. This is the Institute of Management Consultants National Capital Region webinar for today. We're going to talk about protecting your work, the intellectual property survival guide for consultants. And we are recording the session today, so you'll get a link to the recording when this is over. And my name is Linda Howard, and I'm going to turn it over to Lois Rita Rossi, our program chair, to introduce our speaker for the day. Lois?
Thank you, Linda. Thank you, Erin, for being here. I'd like to welcome you all. We have a great topic, and we have an esteemed colleague who is speaking today. I'd like to introduce Erin Austin. Erin is a Harvard-trained corporate lawyer. She has over 25 years experience working in law firms and in service companies as general counsel, as well as in a COO role. Her practice includes a wide variety of business and corporate governance matters, including professional and creative service agreements, government contracts, asset acquisitions, technology, risk management, and workplace issues. And today she's put together a topic to really talk about intellectual property, a survival guide for consultants. And we are going to open it up for questions, and we have left time at the end for your questions. I will be monitoring the chat, so please send your questions. And I'd like to introduce Erin. Thank you.
Thank you so much, Lois and Linda and everyone for joining. I'm happy to be here and talk to you about your intellectual property. As Lois mentioned, I'm a corporate lawyer, so that is my background in handling commercial transactions in services-based businesses specifically. And so what we will cover today is, how to protect your ideas as consultants. Your assets are not, widgets, but your know-how, and you share that with clients and with the world, and sometimes that's harder to protect. And so we're going to talk about the intellectual property that both flows into your business and that flows out of your business. So when we're talking about the stuff that flows out, that's the work product that you prepare for your clients. And then also when it's flowing in, it's the work product that your providers give to you. So I'm going to share my screen now, and let's roll. Let's see here. Share. There we go. Okay, protect your work. All right, everyone can see that?
Yes.
Okay, great. So the most common types of intellectual property that for consultants is going to be copyright law. There are other types, patent, trademarks that I'm sure you're familiar with, but the majority of the work that we deal with is copyright. So that's going to be the primary focus of the talk today. So I wanted to start with an overview of copyright law to make sure that we're all grounded in that. So what is copyright? So copyright is a protection that is afforded by federal law, and it protects the original works of authorship once it's been fixed in a tangible medium. And so I'm going to use the term author and the term authorship, because that's how the copyright law refers to it, but that's not about writing books and about books. When you hear author, that means creator, and authorship, that's whatever you're creating. And so, but yeah, so I just want to make sure that when I use the word author, that you don't think that excludes photographers and things like that. It includes everyone. So it covers everything from the moment it is created. It covers things that are published or unpublished. So it covers, the manuscript that's sitting in your desk drawer the same way it covers, books that are in a bookstore. And what does copyright protect? Again, it covers works of authorship, and that can be anything from poetry and novels, movies, songs, architecture, photography. And what it does not protect ideas, and it doesn't protect facts or systems. So there are other ways to protect those things. And so how does copyright differ from a patent? or a trademark. A patent, that is what protects inventions and discoveries. And then trademarks protect, words, phrases, symbols, even colors or sounds that identify the source of goods. And so all are protected by federal law, but they definitely protect different areas of intellectual property. And so regarding your copyrights, when are they protected? They're protected from the moment you create them, from the moment that they are set down in a tangible form. So as soon as you put pen to paper, as soon as you start typing into your computer, as soon as you put your brush to canvas, as soon as you take your picture, at that moment, copyright protection attaches. And that happens by law, nothing more needs to happen. So do you need to register with the Copyright Office to be protected? No, you don't, because the protection attaches on creation. However, the benefit of registering is that it puts the whole world on notice that you're the owner of this copyright, and it is required if you want to enforce that copyright against someone. So if someone has stolen your material and you want to sue for enforcement, the copyright must be registered before you can bring an enforcement action. And also there's some kind of, damages benefits as well. But generally, registration is fairly simple. It's fairly inexpensive, unlike patents, which are very expensive and you need a lawyer for, and trademarks, which aren't super expensive. They're in the middle, but you pretty much need a lawyer for as well. So that's a little background on copyright law. So with that groundwork in mind, I want to talk about the copyright material that is created or processed in the course of a typical. Now, with this, are you missing the right side of my slides because your images are over there? Because that's how it is for me.
Like no, Erin, we can see the whole slide.
Okay, great. All right. So we will talk about copyright interests in the typical consulting business. We'll talk about the different ways that copyright interests can be transferred among parties. And those three ways are work for hire, assignment, and license. And then finally, we'll talk about how you can control the reuse and possible creation of derivatives of your work. So that's protecting your work. So inventory of your copyright interests. So three broad categories of copyright interest in consulting business. There are going to be the materials that are created by you or by your employees. They're the materials that are created by your contractors, and the materials that are commissioned by your clients. And so the first category, referring to materials that are created that are outside of services for clients. And so first category. The second one, materials created outside of services for your clients, but by someone who's not an employee. And then materials that are created in the course of providing services under an agreement with the client. And those may be original materials, or they may be materials that include one of the first two categories. So materials that are created by you and your employees may include books, blog posts, articles, training materials, presentations. Again, these are the things that you're making outside of your engagements. The important thing to consider here is that under copyright law, as soon as you create something, you are the author and you own all the copyright ownership in that material. When you have W-2 employees and they create materials in the course of their employment, in the course of their services to you, anything that they create, you are the author of as if you created it yourself. And that happens automatically by law. No piece of paper is required for that to happen. And it's important that it is your W-2 employee I know some people sometimes treat their contractors, they think of them as their employees, but if you're not issuing a W-2 for them, then that it doesn't apply. And so you would own 100% of the copyright in anything that you or your W-2 employees create. So for those materials, you can attach a simple copyright notice. Copyright notice is not required for the copyright protection to attach, because it attaches the second it's created, and it attaches whether or not you publish it. So, but if you do publish it, it is a good idea to attach a copyright notice. And again, it's a notice. It just tells people that you have copyright protection. That is not the source of your protection. It's just a notice of your protection. And so the standard is the little C in the circle, which you can find, you know, on your symbols, the year that the material was created, and then however you hold your business assets. For me, I'm a sole practitioner, Erin Austin. If I held it in my law firm, you know, Erin Austin Law LLC, however you hold your business assets, that's what would go there after the year. And okay, so there's no magic to that other than that. Okay, so materials created by your contractors. So if you have virtual assistants, or you hire web designers, graphic designers, people who write content for you, if you use some of the services that are online like Fiverr or Guru, all these are your contractors. Anyone, in other words, anyone who is not a W-2 employee of yours. And so this is important because, you know, someone who's creating your marketing materials, writing your website, you know, maybe doing social media posts for you. If they're not your employee, then, and they are your contractor, they are the author of that material under contract law. And if you do not have a written agreement with them, they own that material. So who owns materials created by contractors? In the absence of a contract that is in writing and signed by the contractor owns the rights in all works of authorship in the materials that they create. So if you have an email with the contractor saying you're going to own everything, who owns it? It was just an email. The contractor, right? Because it's not signed. And so I don't want anyone to think that you can't create a contract by email. You absolutely can create a contract by email. You can create a contract verbally with a handshake, but there are a few areas of law where in order for the contract to be valid, it has to be in writing, it has to be signed, and the transfer of exclusive copyrights or intellectual property rights is one of those areas. You know, other areas you're probably familiar with are real estate and trust and estates, where something has to be in writing and signed. So if you want to own exclusively the rights in materials that your contractors create, then you do have to have something signed in writing with them. So that does not have to be very complicated. Here is some simple language. Contractor hereby assigns to client for no additional consideration all of contractor's rights, including copyrights and deliverables and other works prepared by the contractor in performing the services. And so one thing I want to say is that whatever language or contract you use, it should be appropriate for the type of material that's being created. If you are hiring a ghostwriter to write a book that basically contains your life's work, you know, and all of, you know, everything you created over the course of your career, do not use my very simple sample language. You know, use a formal ghostwriter agreement that contains all the bells and whistles in it. But if you have someone who's, you know, shooting off a blog post for you, or, you know, doing something else, simple is fine. There's no problem with that at all. You know, have a virtual assistant who created the slides for me. And so I do have an agreement with her. I actually own the copyrights and the things she creates for me, but I had an infographic that I wanted to have prepared, and I had this kind of design that I'd sketched out on a piece of paper. And I wanted to, and she looked at it, she couldn't do it herself. But she said, I have a friend who's a graphic designer and she can do it for you. And so great, she arranged it. The graphic designer did the design for me. It was fantastic. I sent her some money by PayPal. That's it, not a piece of paper between us. So that infographic, I do not own the design. She owns the design. What I have is I have a non-exclusive license to use that design, but I do own all the content on that infographic. So, but if she wanted to take that design, put it in her portfolio, and another client said, hey, I like that design, she's free to use that with another client. And so to me, like, that's fine. I don't have any need to own that design of the infographic. It wasn't that interesting. If it had been, maybe I would have. But so she owns that, and that is fine. So now for the meat of what we're going to talk about, which is who owns the material that is commissioned by your clients. And so this is really where people kind of lose control sometimes of their work. It's important that you understand what the difference is between work for hire, assignment, and license. And so this language that determines who owns what in your materials. So when you're engaged by a client, and I'm going to assume that the client is going to require you to sign a services agreement and that it will have some standard ownership of IP language in there. And so you'll probably see something like this, which is your typical work for hire language. And that is contractor agrees that all work product that is copyrightable subject matter will be considered work made for hire within the meaning of the copyright laws of the United States. The client is and will be the sole author of the work product and the sole owner of all rights therein in perpetuity. So what is work made for hire or work for hire? We go back to the employee example. When the employee makes a work as your employee, as soon as it's created, you are the author, not the employee. Same thing, that's one way that work for hire happens. The other way that it happens is by contract. So by contract, you can also have your client be the author of whatever you're creating from the moment you create it, and you're never the author. And that is what work for hire is. And so when it's done by contract, there are a couple of requirements that need to be in place for it to qualify. And one is that it has to be original. It can't be something that's pre-existing. So it has to literally be work that was made for hire. And then the other thing is that it has to be in writing and it has to be signed. And it has to have the magic words, work made for hire or work for hire. Those magic words have to be in there for it to qualify. And then the third requirement is that it has to be one of 9 specific narrow categories that qualify as work for hire. I actually do not know why these were specifically chosen, and they have not been changed, in 100 years. So that it's still the case that these are the only categories that qualify as work for hire. And I have them here just so that you have them when you get the slides. But just quickly, contributions to a collective work, part of a motion picture, translation, supplementary work like an appendix or a forward, compilation, instructional text, test, and that is text, that's not a typo, T-E-X-T, test, answer material for a test, and an atlas. Those, I'm not even completely sure why those last 4, like how they got in there. Like they must have had some lobbyists, working on that to get those in there. But so those are just the the work has to be within one of these 9 categories to qualify as a work for hire, so that the client is the author at the moment of creation. So some of the work that you do may fall within this, some of it, a fair amount of it, may fall without. And so the client will always also have assignment language to make sure that anything that isn't work for hire, I'm still getting all the rights. So then we'll have this assignment language. So with respect to any work product that is not work made for hire, contractor irrevocably assigns to client without any additional consideration in perpetuity all of contractors' rights, titles, and interests worldwide and into such work product. And so here, the client basically gets to the same place, almost pretty much gets to the same place. So all copyright interests in the work product, the client owns it exclusively in perpetuity, 100% of the copyright. So almost the same place as if it was work for hire. The difference is that the contractor is the author, not the client. And as the author, under copyright law, you do have some special rights as the author. And one of those is that after a certain period of time, you can terminate an assignment. Now that time is very long, it's 35 plus years. And so for the probability of something that is created in the course of a consulting relationship that would have any value after 35 years is, slim to none, but that it is there. So there is a difference between the two, but but the client ends up with 100% of the rights. So this is fine if you're creating completely original materials for your client. Let's say you're creating marketing materials. You would not expect to have any rights in the materials that you prepare for the client, and for the client to own 100% of the deliverable is completely reasonable and understandable. But what if you will be incorporating some of your own pre-existing materials into those deliverables? You certainly do not want to assign the rights in your pre-existing material to your client, in perpetuity, and because then you would no longer, have use of that. So what you would want to do is have a carve out. I'm going to give an example of, let's say you're an HR consultant and you are creating a onboarding process for your client's employees. And so a fair amount of that would be custom and original to the client for the client's purposes, but maybe you have some templates or some methodologies that's part of the value of why they engaged you, and that you're going to be including in those deliverables. And so those things you want to be carved out from this assignment. And so the client will then say, okay, then we'll carve it out, but then we need to get a license to use it. And so you'll get something like this. So to the extent that any deliverables include contractors' pre-existing concepts, ideas, models, techniques, etc., which are defined as contractor materials, contractor will retain ownership in such contractor materials, and contractor hereby grants to client a limited, worldwide, perpetual, irrevocable, royalty-free, fully paid up, transferable right and license to use, execute, reproduce, sublicense, display, perform, distribute, maintain, create derivative works, and make modifications and improvements to the contractor materials. So, yes, that has come from a real agreement that I've reviewed. And yes, my head exploded when I saw that, and it should make your head explode if you see language like that as well. So, sure, you have, in fact, succeeded in your materials from the assignment of all rights in the work product, but you granted a license that is so broad that the client can do pretty much anything they want to with it. They can, change it, they can repackage it, they can sublicense it and transfer it, which is another word for sell, and make a bunch of copies of it and distribute it. So you have completely lost control of your materials if this language stands. And this is very typical. And if people kind of, their eyes cross when you see this and you don't read it and don't understand it, that's the way that you lose control of your materials. So I have taken that same language, and hopefully you guys can see that whole page as well, and redlined, which is what I do. Redlining, my favorite thing to do. And you should not be afraid of making changes to agreements. They are used to seeing changes. I'll work with salespeople and they'll send me something and I will redline it, and I only, make changes that are protect the client. And they're like, oh, there's so much red, and it's, they understand it. So do not be afraid to negotiate your agreements. So in order to retain control, to control the reuse and creation of derivatives, I've made some changes here. So back to the definition of the contractor materials, and from there, contractor shall retain ownership of such contractor materials, and subject to contractor's receipt of the compensation for the deliverables that include the contractor materials, contractor hereby grants to client limited, worldwide, non-exclusive, perpetual, irrevocable, royalty-free, fully paid up, non-transferable right and license to use the contractor materials in the form included in the deliverables for client's use alone and not for resale or distribution to others. And so to go back to the changes that I've made here, one, they're going to want to have, the client will want to have an irrevocable license and have it fully paid and royalty free. That's fine, that's fair, you want that, but you do not want to grant that if you haven't been paid. So you want the license to be subject to receiving compensation for your deliverables. I have almost never, I'm pretty sure, ever received pushback regarding adding this with respect to the license to pre-existing materials. They will not accept that to the grant of assignment or the work for hire. They own that the moment it's created. They're not going to agree to that, but they should agree to it here. I've added non-exclusive here. Exclusive is a special word. It's a buzzword. So any license that does not explicitly say that it is exclusive is by default non-exclusive, but I don't like default. I like it to say it's non-exclusive. So there's nobody's confused about that. So I add that there. Here I make sure that it is a non-transferable right. And so there may be circumstances where it is not, it is transferable. Let's say your client isn't the end client. Let's say that you are, your client is an advertising agency and you've just been engaged to prepare, some graphics or something. And so that in that case, the agency will want to be able to transfer it to their end client. And so that will depend on the nature of the services that you're providing. And then so then I've taken out all the kind of broad stuff that would allow them to do anything they wanted to with it. Again, it depends on the nature of the work product. Some of them may apply. For instance, if what you're licensing to them is, photography, then of course they'd be able to display it. But if you're preparing, human resources materials for internal use with their employees, they can put it on their internal, like intranet for the employees, but you wouldn't want them to put it on the public-facing website. And then at the end, I've added a clarification that what I'm licensing to you is in the form that I put it in the deliverables. So you don't have the right to make modifications to it. And it's for your use only. It's not used for your affiliates unless that's part of the deal. And of course, it's not for resale or distribution to others. So those are the protections that we have there. And so your key takeaways are, Have written agreements with your contractors who create materials for you. If you don't have it in writing and signed, they own it. Make sure you carve out your pre-existing materials from the clause that assigns all rights in your deliverables to the client so that you retain ownership of your pre-existing materials. And then when you do license those rights to them, make sure that that license is appropriately limited and not too broad. And that's it. Thank you.
Thanks, Erin. There were a few questions in the chat and people commenting on how valuable the content was. The first question is, let me see. In the graphic design example that you shared, where you hired the graphic designer, you provided the content for the infographic, and the designer kept the designs.
Correct.
The question is, was the outcome exclusive license to use intended by you? I think they're asking, so I guess, Patricia, if you'd like to unmute yourself to clarify the question more, that might be helpful.
Yes, if Erin does not understand what I was asking, or do you want me to clarify, or do you?
Yes, please.
Erin is muted.
Oh.
Okay, so to clarify, what I was asking really was, I guess it would have cost you more, Erin, to have it exactly your way. And so I think that you chose a middle ground or chose the less expensive way because it didn't mean that much to you to have that infographic as it was. So that was your compromise. And is that the case?
Well, it could be. It was not in my case simply because it wasn't that important to me. It was just an infographic that will, go up on LinkedIn and it'll be interesting for a year at the most. And the design wasn't so precious that I wouldn't mind somebody else using it. But that absolutely could be the case that if you want to have, if I'm creating something original for you, if I retain some rights in it, then maybe I will charge you less than if I was going to transfer 100% of the rights to you. But in this case, it would have been she charged by the hour, and I'm 100% sure if I had asked her to sign something that she would have, and I would have owned all the rights in that. But yes, that in concept, yes, it's less valuable to me because I don't have exclusive rights.
So I guess the takeaway is something like, know what you're asking for, know what you're buying, be prepared to maybe categorize it 3 ways, like really valuable, not very valuable, or something in the middle, and then work your agreement around that.
Absolutely. Like in the ghostwriter example, if someone's creating something that's super valuable to you, make sure you have all the rights that you need versus someone who, maybe is, shooting off an infographic for you, definitely.
Thank you.
So Erin, I have a question. In my consulting business, I've worked with several large organizations, large original equipment manufacturers that have, a short list of major competitors. And in one contract, we were asked to say that we wouldn't do similar type of work for one of their competitors.
Mm.
And so how typical, reasonable is that? Because it actually became somewhat heated during trying to finalize a service agreement.
Yeah, non-compete, that's a different animal. But generally, I'm personally anti-non-competes. I'm pro confidentiality agreements, like anything that we share, it's confidential. I will not use with any other client. But part of the value that I bring is my experience in this industry. And if I can't work with other people in this industry, then that hurts everyone. And so I would certainly resist non-competes, but absolutely agree that you will not use those materials for other clients. So yeah.
Thank you. So there is a question for somebody who has some audio challenges. And the question is, Does a license that includes deliverables with the client's logo? I asked her to clarify that. I don't really understand the question. Maybe you understand the question. I think if the deliverable is a logo,
Right.
is it considered a work for hire? They own it.
It may not be work for hire because remember the 9 categories. So it may not be a work for hire, but I would certainly expect that they would ask you to assign 100% of the rights to them. Like you should not use that logo for anyone else. And that should absolutely be original. They would expect it to be original, and they would expect to have exclusive use of it. And they would want to see that 100% assigned to you. You may have like a process for coming up with logos. You may, have an intake form where you talk to them about their personality and their favorite colors, and then you use that to create the logo, and that methodology would always be yours. But the final result of the logo, I would expect the client to own that 100%.
Yeah. So there is a question from Hillary. Hillary, if you'd like to unmute yourself and ask about adding copyright notes, footers to the materials that you're creating.
Great, thank you very much. Erin, this has been fabulous, so clear and so helpful. So I'm really, really grateful to have been part of this today. So I write a lot of training materials. I create participant books, slides, and so forth. So do I understand correctly first that without my doing anything, they are copyrighted to me?
Correct, they are, absolutely, upon creation.
And then would it be a good idea for me to start like in a footer on my slides and participant materials, putting that copyright language as an extra protection?
Yeah, absolutely. Again, it does not affect your protection if you don't have it, but it puts everyone on notice that this is your original material. And so, that absolutely.
And particularly
certainly your training, certainly if there are hard copies of training materials that you're handing out, like in a room, I would certainly encourage it there. The slides on, PowerPoint of a webinar, probably don't have a ton of, depending on the nature of the slides, may or may not be something that you're always worried about, but definitely your training books and things like that, I would.
And if I create a certain process for teamwork or something like that, I would definitely want to at least stake my claim, because that would be copyright to me. Is that correct?
Correct. When you put it down, not if it's in your head, but if you put it down in writing in a booklet, then it is.
Or on my website or wherever
Or on
it
your
might
website,
go.
yes.
Okay.
Yeah. Mm-hmm.
Really, really helpful. Thank you so much.
Okay, so there is another question, and it is, as a subcontractor, I create materials for federal agencies. Without any language in our contract, who owns the materials used with the end user by me or others with the primary, I'm assuming she's trying to say with the primary. So it's a government contract, materials are delivered to the agency and then to end users. Who owns the materials if there's nothing in the contract?
Meaning there is a contract, but there's no language regarding ownership?
That's what it appears, yes.
Well, yeah, I mean, again, in order to transfer copyrights, exclusive copyrights, you must have it in writing, signed. And so if there's not something in writing signed transferring exclusive copyrights, then the person who creates it owns it, and the person who receives it has a non-exclusive license.
Thank you. Thanks for the clarification. Are there any other questions? I'm not seeing any other questions in the chat. If anyone would like to, feel free to unmute. We have Erin and all of her knowledge and experience, and I'm sure there's probably some other questions.
Hi, I have a question. I have like 8, but there you go. Erin, first of all, how do you mentioned NDAs. Is there are about as many NDAs as there are lawyers on the planet. So do you have a favorite template that's particular to consulting and coaching kinds of things, or also software development, where they may be working on something that, you don't want them to talk about even to their significant other?
Yes, yeah, I do have a template, and they're essentially the same. And basically, it prevents you from. I mean, they call it a non-disclosure agreement, but it's a non-use and non-disclosure agreement. So one, you agree not to disclose it to any third parties. If you have employees, you only disclose it to the employees on a need-to-know basis. If you have, people like a lawyer or an accountant that may need to see it, then you're responsible for them also maintaining the confidentiality. And then it also is non-use, meaning you will also use it only in performing your services, and you can't use it for yourself or for any other purpose. And that those are pretty much ubiquitous in any type of knowledge-based industry. So I imagine that you see them all the time. Your clients present them to you. If they want to talk to you about what they'll want you to sign one just to talk to you about whether or not you get to bid on something, because they want to be able to tell you about what their issues are. And so, there are, I can do a webinar on it. There are, a couple of key things that you'll want to look out for, which is, basically it's about carve-outs. To make sure that anything that you already know, because there are some things that you will already know or may find out from other places, aren't you would not be in breach of that agreement if you use knowledge that you learn elsewhere. And then also sometimes clients will sneak in non-compete language in NDAs, and that should not be in there. And so you do need to read them, from beginning to end to make sure that they're appropriately limited as well.
Yeah, I've edited many. One more quick follow-up that's related is if we have, a lot of us have software that we're developing in one way or another, especially in this virtual universe where we have to find creative solutions, or we're developing an app or a technology. It sounds like your NDA would apply to that, but does that all in the non-use, limited use, just not whatever you call it, just using it for this? Does that also include that the like if I'm having somebody develop software for me and they sign that agreement you just mentioned, does that also mean that I own the software, or does that have to be separately done in a separate work for hire kind of agreement?
Yeah, the ownership of the transfer of ownership of the material would be in the work for hire agreement, whether it's a scope of work or a statement of work or a services agreement, a developer agreement. The NDA is literally just about keeping the information that's shared confidential. It does not transfer any ownership rights in that document.
Erin, there's a follow-up question to the previous question about working with the government agency, an agreement that has no reference to copyright, and you clarify then that the contractor retains that. And the follow-up question is, what if the government client is selling the materials? Who owns that and has the rights to the proceeds? So it sounds like this consultant is in an arrangement with a government entity that has a very thin agreement. A lot of these details weren't handled, and now has created information that the government entity is now selling.
Yeah, I mean, I just say generally, because I hate to give any legal advice without seeing the documents, but generally it sounds like the government has a non-exclusive license and that there's no limit on that license. It's not exclusive, but it is unlimited. So there's nothing to say that they can't sell it. So.
Got it. Okay, somebody else has a question. Linda, why don't you ask your question while I'm reading the chat, please?
Okay. Yeah, so my question was, I do a lot of work in project management, and so when I'm doing preparing my own training materials or preparing for a speaking engagement of some sort, I may be out there reviewing, researching on Google, and you can find 50,000 different ways of saying the same thing.
Mhm.
And who knows where the original thought or idea came from? What's the boundary between copywriting, something that's already copyrighted, and your original way of putting it down on paper versus some ideas on how you can, help somebody implement things in a certain way, and you write it down, and maybe it was one of the 50,000 ways that you didn't look at. Where do you
Right.
draw the line, and how do you make sure you don't violate some of those?
That's a tough one. Well, there is a concept called fair use, and it is fairly complicated, and it is more art than science. But basically, it means that you can use copyrighted materials in certain circumstances, so long as that use is fair. And so you can take excerpts and you can paraphrase and you can incorporate it into your materials. And the idea is that so long as you don't take so much that you become a replacement for the original, so that the original kind of loses its value because of what you've taken from it, then you fall into fair use category. The problem with fair use is that it is a defense. So if it's a defense, that means somebody sued you. So you don't want that. But you can use it as a guideline. Like, okay, yes, we'll find a gazillion white papers about this and that, and you'll say, okay, this is interesting and that's interesting, and you'll take those pieces and kind of make them your own, combine them with your own materials. And I think that just common sense, that you're not like lopping off, entire, pieces, and you are putting your own spin on them and making them, adding value, which is kind of really the basis of, all progress. So, yeah, so
Okay.
probably okay.
And then on a related question, I had a client the other day that asked me, is any of my training material proprietary? And to me, in my head, proprietary means if like Hillary was talking about, if I created my own model that I believe no one else has looked at it that way, and then I wrote it down on paper, that would be a proprietary.
Correct.
If I'm summarizing information that's already out in the world, as we've just described, that wouldn't be proprietary, even though I might put a copyright on it because I'm putting my own spin on it and incorporating in my own materials.
Right.
Right? Well,
It's kind of two things. Like, the copyright would protect the way you have expressed it in writing. So that protects literally the words that you put on paper, versus your methodology would be protected. Like, if you wanted to, you could protect it with a patent. Probably you wouldn't, but that would be how you do what you do.
Okay.
If you've reduced it to writing, then that absolutely would be proprietary and protected. But if it's yeah.
Okay. I think the answer to them is
okay.
Right.
Okay.
I said no.
Okay. All right.
Okay. Thanks.
Yes. Hillary had a follow-up question. Hillary, if you'd like to unmute.
Thank you. I'm sorry, I don't mean to be hogging the space, so I appreciate the opportunity. So Erin, originally when you were talking about copyright, you said you can relatively cheaply, I believe, go and register it with the whomever, I'm not even sure.
U.S. Copyright Office.
U.S. Copyright Office. When would you want to do that? Again, it sounded like to forestall lawsuits, but how might you have a sense of when that, I think you are understanding my question.
Yeah, I mean, I don't know that. I think that you would, certainly books, certainly, if you have like a evergreen training materials, I'm wondering how often people copyright their websites. I imagine few do, depending on, but if they have like lots of, if they have their trainings on there, obviously they would, but if it's like a blog, I would say they probably do not. But you would, basically need to file the entire version needs to be filed in the Copyright Office. There are some exceptions for software where I think you can take pieces of the software. You don't have to file the whole program. But generally, a copy of the entire thing needs to be filed in the Copyright Office. So it would depend on on what it is, but
So I think what I'm hearing is really, I don't have to worry that much unless it's some brilliant, big piece of thing that I think other people, I'm not all that. So
yeah. Anything that you think would be evergreen, I let me put it that way.
Okay.
Any evergreen material, I would say.
Perfect. Thank you so much.
Or that will be broadly distributed.
Okay. Wonderful. Thank you again.
Yes, whoever's logged in as Samsung, please unmute yourself to ask your question.
Hi, this is Brent, and I apologize for that. I hope you can hear me.
We can.
Okay.
Okay. I've tried many times to log in via computer, but I finally had to use my mobile phone, and I was late. So hopefully this is not redundant. I've just currently working on a project for a Fortune 1000 company who wants to better understand the landscape of the major players in their space and the M&A activity that has occurred under each of those key players. As a result of that, I would like to then subsequently, after finishing the project, potentially use that same information with either those same key players or others who are interested in entering that space. Are there any ethical or legal restrictions on that?
Yeah, it would depend on the engagement. So if the client has, assuming you've signed an agreement and the language in the agreement says that they will own all the work product, then they would own all the work product and you would not be able to use it with other clients or for yourself.
Well, actually, we didn't sign a formal agreement, oddly enough, because I've known the guy for quite some time, and so.
Okay, so you have. All right, so if you don't have a legal issue, then you do have a ethical issue. Yeah, I mean, if it's the kind of material that he will then be using in a way that people will think that that is his, like, let's say it's, he's doing a presentation with this material and people think, oh, that's his material. And then it shows up on stage with somebody else. Like that's the kind of thing, obviously, that even though you would have the right to do that, maybe that would damage the relationship. So.
Okay, good point. Well, in reality, it'll be a lot of public domain information that I have pulled together along with my own knowledge of working in this space for almost 30 years. So, but I get your point, and I'll walk that line carefully. In reality, we have also agreed that the work product will be mine and that they'll be able to use it, the information, to guide their own strategy in the company.
Okay.
That was a good question, Brett. Julia, please unmute. I know you have a question.
Hey there, Erin. Thanks for doing a lot of good information today. I have a book that's going to be coming out this year, and there are, like, I had in one of my boot camp classes, a client actually drew a diagram of a house when I was talking about policy and procedures. So I love that graphic. But as long as I give him the copyright on that, and I'm gonna ask him, but is that the way you should do that? That's question one. The other is, when the book is published, would you publish it under Stanford LLC, my legal name, or Julia Demkowski, which is also my legal name?
So first, in the boot camp, did the participants sign anything that says, I'm going to take pictures, we're going to create materials, and who will own those photographs, the materials that are created during the boot camp?
I didn't specifically say if you draw a picture representing what I'm teaching you. Didn't say that, but I did have an agreement for any pictures or anything that could be used for marketing. So I did get that. And then they had non confidentiality, because I only let 10 industries in for a boot camp. So, but that was between them.
Right.
Obviously, I'm not going to go on the street and talk about them.
Right.
No.
So, okay. So
Is his work, his picture, and then I'll have other charts and graphs in the book that I won't do. A graphic artist will do.
Generally, it sounds like the artist owns the copyright, already owns the copyright in the picture, and that that you probably have a non-exclusive license to use it. I think it would be good form, certainly, to let the person know and to just ask for permission to use it. You always want to have clearances when you're going to publish a book. You want kind of zero risk, because you don't want to have to go back to the publisher and republish something. So you want your risk to be as low as possible about any content in the book. So go back and get simple one-page permission to let them know that you're going to use that in the book.
Okay.
And then as far as how you own it, like your book is well, it depends on how. I mean, it's a business asset, like your computer. So if you can do it either way. I mean, if you hold your assets in your consulting company, you can put it there. But also, a lot of people will still keep it in their name and have that copyright in their name because that's part of their brand as Julia, So you could do it either way.
Okay.
But at the end of the day, if you put it in your LLC, and someday, it's an asset there, and someday you close up your LLC, you'll contribute all those assets to yourself, like your bank account and whatever else, and it'll come back to you. I mean, so this will happen.
Okay. Thank you.
Great. Are there any other questions? Well, it is just about 1 o'clock. So Erin, on behalf of the entire membership team and everyone who's joined, we'd like to thank you for providing really great relevant content and a great dialogue and allowing us to ask very good specific questions. I think everyone found this very thought-provoking and making us think about how we can be better consultants and really better protect our intellectual property. Thank you for your contribution.
All right. Thank you. It's been a lot of fun. Thank you so much.
We will send a recording out, and feel free to email Erin directly if you have a specific question.
Yes. And I'm also on LinkedIn if anyone wants to connect. Happy to connect.
Thanks, everyone.
Thanks, Erin.
Thank you.
Thank you.